It was alleged that on the 10th day of November, 2009, one Mr. Kebe, who was a police constable, claimed that himself and one other policeman known as Bawa were on patrol at night at World Bank Housing Estate in Wahia, Abia State. He claimed that they came across 3 men attempting to burgle and steal from a house. It was alleged that upon sighting the 2 policemen, they ran while Corporal Bawa pursued 2 of the burglars, while Corporal Kebe remained at Road 6 to give backup surveillance. One of the armed robbers, who noticed that Corporal Kebe was all alone, came from behind with a machete to attack and disarm Kebe of his gun. This resulted in a struggle and Kebe shot him in self-defense. On the other hand, the case of the prosecution was that the deceased was a student in one of the secondary schools in Enugu, who was visiting his father for the first time at Umuahia. On the 9th day of November, 2009, his father traveled to Aba and left the deceased at home only to return the next day to meet his son's corpse at Federal Medical Center Umuahia. The prosecution stated that Corporal Kebe broke into the deceased residence, dragged him out and shot him to death. Corporal Kebe was charged with the offense of murder contrary to Section 319 Sub 1 of the Criminal Code Laws of the Eastern Nigeria 1963, applicable in Abia State, before the High Court of Abia State. After the trial of the case, Corporal Kebe was convicted and sentenced to death. Aggrieved by the decision of the trial court, he appealed to the Court of Appeal, Owerri Judicial Division. At the hearing of the appeal, Learned counsel for the appellant argued that the incident leading to the death of the deceased raised doubt as to whether the appellant Corporal Kebe went to the house of the deceased, dragged him out of his sleep and killed him in front of the house as alleged by PW1, or whether the deceased attacked the appellant at his duty post at 3 a.m. in the night as stated by DW1. He submitted that the trial court ought to have resolved this doubt in favor of the appellant Corporal Kebe, especially for the fact that the appellant was the only person with the deceased when the shooting took place. He further submitted that the deceased and his gang carefully locked up the premises from inside the gate, to give the impression that he slept therein and then scaled the fence to carry out his unlawful activities. He argued that the police could not have killed him inside the compound and carried the corpse over the fence to the street, when the deceased had the keys in his pocket. Counsel also noted that it is in evidence that items recovered from the deceased includes a bunch of keys, a machete, and a phone. Learned counsel for the appellant further argued that if the premises where it was claimed that the deceased slept in was locked from inside, and not possible to be opened from outside, then it could not have been possible for the police, that is the appellant and his team, to enter the premises, drag out the deceased, took him to the street and shot him dead. He submitted that these doubts ought to have been resolved in favor of the appellant, especially considering the fact that criminal cases under our legal system are decided on proof beyond reasonable doubt and not on a balance of probability. On the second issue, counsel also argued that the appellant Corporal Kebe acted in self-defense as he believed that the only way to save himself from death or grievous bodily harm was to use his gun since the deceased came behind him with a machete trying to disarm him of his gun. He submitted that the trial court failed to consider all the defense raised in evidence. On the third issue, learned counsel for the appellant argued that the prosecution failed to prove the guilt of the appellant because of the unresolved doubt in the circumstance of the death of the deceased and that the prosecution failed to call some material witnesses such as Corporal Bowo, who was on duty on the night of the incident with the appellant and whose statement is contained in the record. Counsel posited that this leaves the case of the prosecution with a presumption that if these witnesses were called, their evidence would be against the prosecution. He finally urged the Court of Appeal to allow the appeal and discharge the appellant. The Director of Public Prosecution Abia State, who was the respondent at the appeal, submitted that by the evidence of PW1, PW2 and PW3 and the admission of the appellant, the prosecution proved the charge against the appellant. He also submitted that the self-defense raised by the appellant was neither here nor there. He argued that anyone who shoots another person 15 bullets with the gun as the appellant did in this case clearly intends the natural consequence of such an act as held by the case of JUA against State. He also noted that the appellant failed to prove any of the ingredients necessary to succeed in his claim of self-defense as provided in the case of Omoriji against State. The learned DPP further submitted that the claim that the appellant acted in self-defense is unbelievable because PW1, who was the father of the deceased, testified that his house was destroyed with the doors broken, which ordinarily leaves the impression that the appellant broke into the house, brought out the deceased and shot him dead. He further argued that the claim that the deceased came from behind to disarm him of his gun holds no water as there were no injuries or machete cuts on the appellant's body. Therefore, it cannot be said that his life was in danger. Furthermore, the DPP contended that by the evidence of PW2, who was the police investigation officer, the appellant was not authorized to carry arms and the activity was not approved by the Commissioner of Police. Counsel noted that this fact as contained in the records remained unchallenged and thus good and credible evidence which the court ought to rely on. He urged the Court of Appeal to dismiss the appeal and uphold the decision of the trial court. The appellant counsel replied on point of law and argued that the issue in this appeal was not whether the deceased died as a result of the shooting by the appellant but as to under what circumstances the shooting of the deceased took place. He submitted that the appellant did not need to wait to sustain machete injuries from the deceased before he could act in self-defense. He noted that it was in evidence that the appellant was in a reasonable fear of danger before he used his gun on the deceased. He also noted that PW2 under cross-examination informed the trial court that the appellant was acting under the official instructions of his superior officers. He urged the Court of Appeal to resolve this appeal in favor of the appellant. To resolve this appeal, the Court of Appeal held that there is no doubt that the deceased met his death in the hands of the appellant, and that there is no doubt that the death of the deceased by gunshot from the appellant happened at about 3 a.m. at the World Bank Estate in Wahia on the November 10, 2009. The court held that in the case of Idoho against State, the Supreme Court, Quorum Adekai JSC held that to sustain a conviction in a charge of murder, the prosecution must prove the following ingredients which are very essential and mandatory. A. That the deceased died. B. That the death of the deceased was caused by the act of the appellant. C. That the act of the appellant was intentional with the knowledge that death or bodily harm was its probable consequence. The court found from the records that it is undisputed that the deceased died, and that the death was as a result of the act of the appellant. However, what is left to be established is whether the act of the appellant was intentional with the knowledge that death or bodily harm was its probable consequence. To resolve this doubt, PW1, who was the father of the deceased, testified before the trial court that he left his house in the evening of November 9, 2009 to ABA and returned on the November 10, 2009. When he got home, he discovered that his house was not as he left it. Many things were destroyed in the house, including his door. That he did not see his son whom he left in the house and that he would not know what was used in cutting the door into pieces. He started shouting and some people informed him that a policeman from a nearby World Bank estate came to his house that day and killed his son in front of the house. When he went to the police station at the World Bank estate to know why they killed him, he was told that the incident happened between 3 a.m. and 4 a.m. of November 10, 2009. He was then directed to the Federal Medical Center Umuahia where he saw the corpse of his son. The court also found from the records the testimony of PW2, an inspector of police who informed the trial court that during his investigation, his team and the appellant were at the scene of crime where they discovered that the house of PW1 was broken into and the deceased was brought out and shot by the side of the house by the appellant. He also informed the trial court that the state CID transferred their own case file wherein he saw the picture of the deceased holding a machete on one hand, and handset and bunch of keys on the other hand after he had been killed, which had never happened. PW2 also informed the court that the appellant admitted killing the deceased when he was on duty at night around 3 a.m. That the appellant booked 15 rounds of ammunition which he emptied on the boy. He noted that the appellant said he was an armed robber. That the appellant never mentioned where and when and whom the deceased robbed. He further noted that there was no case of stealing against the deceased, there was no report of stealing, that the appellant purposely for no just cause killed the deceased. After his investigation, he recommended that the appellant be tried by orderly rule. During cross-examination, PW2 informed the trial court that the handset, machete and keys in the hand of the deceased were planted there by the police. The court also read through the defense of the defendant wherein he stated before the trial court that while on duty at about 3 a.m., they saw 3 armed men. Corporal Kebe chased them. He followed behind. 2 of them were chasing them. He did not know that one is still behind with a cutlass. He attacked him to disarm him. He struggled with his rifle to disarm him. The person that attacked him was huger than him and taller than him. When he attacked him, he was shouting seriously. It was on that process of the attack, before then, that his rifle was on rapid. If it is put on rapid, if you press the trigger, the ammunition would just start firing. In the night before the incident, the people residing in the area called their DPO that people were robbing in that place. That was why he put his rifle on rapid fire. So in the process to disarm him of his rifle, he acted in self-defense because there was no other thing he could do. That he touched the trigger and the gun fell down. That he did not deliberately kill the deceased. That he did not know the men that attacked him before the incident. That he did not go to his house to drag him out before killing him. The court then noted that from the evidence placed before the trial court, it was clear that the deceased was killed by the appellant. That it was in evidence that the appellant killed the deceased in self-defense. In other words, he intended the death of the deceased to defend himself when he was being attacked by the deceased. The court noted with regret that Corporal Kebe, who was on assignment with the appellant at the material time of the incident, was not called to testify as regarding what happened while on duty with the appellant and their encounter with the armed robbers. The court also noted that the alleged armed robber who attacked the appellant at his duty post was armed with machete while trying to disarm the appellant of his gun, and to defend himself, the appellant fired its bullet on the deceased to prevent himself from being disarmed by the assailant. The court held that from the fact of this case, the appellant did intentionally kill the deceased. He dragged the deceased out of his residence, pumped 15 rounds of bullet into him and left him dead, claiming the deceased was an armed robber, which he never was. The court then held that there was an intent to kill by the act of the appellant. Thus, the prosecution proved its case beyond reasonable doubt. On the self-defense raised by the appellant, the court reproduced the provisions of Section 287 of the Criminal Code Act and raised the question as to whether the scenario painted by the appellant in his defense existed or believable. Was the appellant ever attacked with a machete to disarm him of his rifle? Was there any struggle between the deceased, an 18-year-old secondary school boy, and the appellant to warrant the belief that there is no other way the appellant could have saved himself if not by pulling the trigger? The court noted that it is pertinent that no witness testified for the appellant in support of his defense, not even his colleague, Corporal Kebe, which therefore rendered his defense of self-defense unbelievable and unacceptable. The court held that all the defense story was an afterthought to cover his grievous crime of terminating the life of a teenager whom he dragged out of his house and killed by sporadic gunshots. The police placed keys, handset, and machete in his hands to attempt to cover up the gruesome murder of the deceased by the appellant. The court also held that the defense is not apparent on the face of the evidence placed before the trial court, and thereafter there is no veracity in it to avail the appellant. The court further held that self-defense will fail if the prosecution shows beyond reasonable doubt that what the accused did was not done in self-defense. The onus is on the prosecution to disprove the self-defense and not on the accused to establish his pleading. In conclusion, the court held that by the self-defense of the appellant, it is clear that he committed the offense of murder. However, the defense cannot exculpate him because no credible evidence was placed before the trial court to prove self-defense. Thus, the appeal failed and was accordingly dismissed. The Court of Appeal upheld the death sentence of the appellant as decided by the trial court.